moderator for today. So the purpose of this webinar is to give insight into the importance of having a will and how it impacts the daily lives of South Africans. The Office of the Chief Master and the Master's Officers deals with 5 primary core functions, one of which is deceased estates. And with deceased estates comes the issue of whether or not the deceased had a will in order to govern the administration of his estate. Statistics shows us that approximately between 25 to 30% of estates reported at the master's offices does not have a will, and therefore the estate devolves in terms of the intestate succession. So this afternoon, we have a panel of ladies that have prepared some presentations in order for us to listen to and take home and implement where we feel that we have not made a sufficient provision. We have 4 presentations that will be taking place, which will be the significance of the National Wills Week, the administration of deceased estates, the importance of having a will, and the registration of marriages regimes and how they impact on the administration of deceased estates. Our first speaker up this afternoon is Ms. B. Rangata. Ms. Rangata is an admitted attorney of the High Court, brings over 24 years of legal experience. She holds an LLM in international property law, LLB, and a BProc. Her journey includes 20 years tenure at Maponya Attorneys, where she held various positions, including the CEO and later co-chairperson. In November 2021, she founded BR Rangata Attorneys, a law firm registered at the Legal Practice Council. She is a legal professional and a dedicated community advocate. She currently serves as a member of the Gauteng Provincial Council and is a member in good standing of the Black Lawyers Association and South African Women's Lawyers Association. Her work extends beyond the courtroom and partners with several NPOs to advocate for the rights of the marginalized communities. She is particularly passionate about educating women on the issues that affect them, such as customary marriages and wills. As a legal practitioner, she has served in institutions like SARS, Eskom, University of Mpumalanga, and others. She has chaired disciplinary hearings for Eskom and board of inquiry for institutions like the Railway Safety Regulator. She also worked at the State Capture Commission, where she worked closely with the chairperson of the commission. The principles of Ubuntu drive her, and she continues to work with communities to improve their lives. She has trained over 50 candidate attorneys and continues to mentor university students, preferably 3rd and 4th year law students. She's a firm believer in pull as you rise, and the best way we can better equip those who come after us is to create opportunities for learning for upcoming lawyers. Please help me welcome Ms. B. Rangata from the Law Society of South Africa. I hand over to you, Ms. Rangata.
Thank you very much, Ms. Daniels, for that beautiful introduction. For a second, I thought, who are you introducing there? Is that myself? I really appreciate it. Let me take this opportunity to welcome everyone to this webinar. My job is very simple. I'm here to tell you about the importance of wills. The LSSA, which is the Law Society of South Africa, it is an institution that serves the interest of the public as well as the legal practitioners. Since 2018 and 2008, sorry, the LSSA saw the initiative of creating this National Wills Week. Why is it important for us to reflect on the National Wills Week? It is important because we have since, as you said as well, Daniel, that there is a history of non-awareness of our people, our communities about wills and the importance of wills. we are going to be told by one of our speakers about more in detail about what a will is, who can make a will, what do you need for you to make a valid will, who can benefit from your will, what are the applicable laws of making a will. The Law Society of South Africa saw the importance of bringing this valuable service to the public, because we understand that we are serving the communities that are marginalized. Not everybody has the resources to be able to be afforded an opportunity to see a lawyer. Not to say that lawyers are expensive, but we know that you need to have the resources for you to be able to afford a lawyer. This week of the 16th of September until the 20th of September 2024, the Law Society of South Africa has made available number of lawyers, I can say hundreds of lawyers. If you go to the website of the Law Society, you will see that there's a huge number of lawyers across the whole provinces, the 9 provinces. We've got hundreds of lawyers that have made themselves available to assist all members of the community. I just want to reflect on this initiation. This initiation supports the importance of having your will done by somebody who is knowledgeable and has the expertise of the legal environment. We will hear from the registration of customary marriages how important it plays in making your will. In terms of determining that your regime is well defined, your marriages is well registered, all the applicable laws that you will need to be aware of. It's important for you to have a lawyer to draft a will for you. I just want to say again, the LSSA is not working alone. We've got other stakeholders like the Department of Justice, the SAOLA as well, together to have this humongous responsibility of going out there and making people aware that we have the responsibility and the freedom of drafting our own wills. So we are here as lawyers, amongst others, and I know that there are certain people that offer the resources of drafting wills. I want to speak on behalf of lawyers and also to make sure that we understand that it is important to have a lawyer. I'm not restrictive, that we are here for the rest of the week to make sure that whoever demands or needs a will, we are here for you. We'll draft your will. We will not be updating any wills. We will only draft a basic will to make sure that it complies with the requirements, to make sure that it is not invalidated when you are no longer on earth. I think I'm going to leave it at this stage. Thank you very much for this opportunity, and we're going to enjoy all the speakers that have been lined up for us. Thank you very much.
Thank you, Ms. Rangata, for that presentation that you have made. I just want to encourage participants that there's a Q&A. So if you feel that you have a comment to make, a remark to make, or questions that you want to pose, because after the speakers, we will be having a Q&A session where we will be answering your questions. So that was Ms. Rangata from the Law Society of South Africa. The next speaker on our list is Ms. H. Venter from the Office of the Chief Master at the Department of Justice and Constitutional Development. A brief biography of Ms. Venter is, Ms. Venter is a Deputy Master at the Office of the Chief Master. She obtained a BProc degree in 1995, and after doing her articles, she joined the Department of Justice and Constitutional Development in February 1998, where she worked in Kimberley Master's offices as an estate controller. In 2003, she was appointed as an assistant master in the Bloemfontein Master's office, and in 2005 was transferred to the Office of the Chief Master, where she is currently working. She assists with strategy and policy issues, uniformity, complaints, managing the beneficial ownership register, reviewing of relevant and applicable legislation, and anything in between. I now hand over to Ms. Patrice Venter. Thank you.
Thank you, Ms. Daniels, for the introduction. I will be shortly explaining what the administration of estates actually involve, because we all hear we have to draft the will, but what happens after we pass away? So I will be sharing a presentation and I will be going through that. So first of all, a estate needs to be registered with the master. You have an estate when you have assets or a will. But what does the master do? The master does deceased estates, insolvencies and liquidations where companies or people are bankrupt. We register trusts. We have curatorships where we appoint curators and administrators for people that are not able to handle their own affairs. And then we also manage the Guardians Fund, which basically consists of funds which minors are which are due to minors out of estates. There's 16 masters offices countrywide, and we also give our services at 402 service points, which is magistrates courts countrywide. 290 of these service points are actually linked directly with the master's office. So though you might use the service at the magistrate's court, you are actually being assisted and your matter being reviewed by a legally qualified person in the master's office. This is just a list of where our offices are. It's basically one at each seat of the High Court as well. So what do we do with regards to deceased estates? First of all, the master appoints the executor or the master's representative. That is the person who will ensure that your estate are being administered in terms of your will, if you drafted one, or otherwise in terms of the Interstate Succession Act, if you did not leave a will. The master, with regards to that, checks the validity of your will, because there's certain formalities that a will needs to comply with, which will be discussed a little bit later. And then depending on the value of the estate, there's different types of appointments. And our turnaround time is approximately 15 to 21 days for issuing a letter of appointment in a deceased estate to the executor if we received everything in order. Once the executor has been appointed, the executor is then charged, step basically into the shoes of the deceased and is then charged to administer the estate. This will involve, amongst others, lodging of a liquidation and distribution account, which is basically an account that shows all your assets, all your liabilities, also who it should be distributed to. And the master then checks this to make sure that it complies with the law, that the distribution is actually in terms of your last will or the Interstate Succession Act, and that everybody's interest is protected. The master will ensure that, well, the master does not distribute the inheritance, but ensures that the executor does so correctly. And should there be any objections, the master will then can then rule on those objections or refer them to court to take a court order on that. Again, our turnaround time is around 21 days for examining such an account. The master also protects the interest of minors in that with regards to child-headed households. If you pass away and you only leave children, the master refers this estate to Legal Aid South Africa to assist. We will then do a means test, and if you fall within the categories of providing of assistance, the master will assist, the Legal Aid South Africa will assist those children free of charge with the administration of the estate. We ensure that the inheritance of the minor is protected. Cash is paid into the Guardians Fund, or if you did indicate so in your will, a trust should be registered. Then the trust is registered with the master. and the trustee is appointed. And the master also oversees where the sale of the property of minor of immovable property, the permission of the master is needed to do that. Okay, now why must I report my estate with the master? First of all, someone needs to be appointed to administer your estate because you are not there anymore. So someone needs to step into your shoes and make sure that your assets are divided amongst your heirs in the way that you would have wanted it. Remember that the person who is appointed to administer the estate does not mean that that person is necessarily your sole heir. The person is merely appointed to oversee, to gather the assets, pay the debts, and pay who should get the inheritance. So this is what that person do. They establish the correct assets and liabilities, pay the debts. They will transfer your house, transfer your car. If there's any claims for maintenance against your estate, it should be lodged with this person, who will then consider it and put it as a liability against your estate if he accepts it. He ensures that the correct heirs receive what is due to them. And like I indicated, Legal Aid South Africa also assists. And the executive will also ensure that your creditors are paid and protect the interest of the minors. So, reporting an estate. When do I report an estate of a deceased person? In terms of the Act, an estate should be reported when someone left assets or a valid will. Now, what is an asset? Asset is anything that you had, that you left, a bank account, even if there's only 10 Rand in that bank account. Furniture, it doesn't need to be big things or expensive things. Anything that you owned that needs to be divided amongst other people after your death is assets. And then also when you left a valid will. The Act also says you have to do so within 14 days after death of the deceased. However, it's not always possible because sometimes it takes longer to get the death certificate and so forth. But it should be done as soon as possible after you receive the death certificate with the master. Now, where do I report an estate? The good news is that you don't need to go anywhere anymore. You can do it online in the comfort of your own home. There is a link available on our website where you can access the deceased online registration system, and all the necessary forms and information you are prompted to complete, and you lodge it. You immediately receive your estate number, and the master can proceed with the process. But should you not be able to do so from your home or from the internet, you can go to the master's office, but it should be reported in the master's office in whose area of jurisdiction the deceased was normally resident, meaning that where this person resided in the 12 months prior to his death, normally, that master's office will have jurisdiction. If it's a very small estate and there's no will, a small estate is less than 125, you can go to any of the magistrates' courts, that service points of the masters, and they can also assist you. If it's one of those 290, which I indicated, that's directly linked with the master's office, they can do estates with no wills up to 250,000. Now, it's important to note that this value is the value of the assets before deduction of the liabilities. So it's not what will be left in your estate, it is what is the value of your assets. Who can report an estate? The death is to be reported by any person having control or possession of any property or document being or purporting to be a will of the deceased. How? Like I indicated, the estate is reported by lodging certain documents with the master, and then, as I indicated, you can now do it online in the comfort of your own home. Okay, so I already explained this. The estate must be reported by an interested party to the master, and I explained to you what to do if it's less than 125,000. But in those estates and also the estates less than 250,000, the master will appoint what we call a master's representative. That person will get the appointment, and the assets that you have and the assets that that person may deal with is then listed on that appointment letter, and that will be the only assets that the person can actually deal with. So he cannot lie to the master and not indicate that there is a house, because the house will not be on his appointment letter and he will not be able to transfer it. The benefit of a 18.3, what we call it a 18.3 appointment, is that once you've received the appointment, there's no further duty on you to report back to the master's office unless specifically indicated by the master's office, where there's, for instance, minors' money that need to be paid into the guardian's fund. So this is also applicable on the estates of less than 250,000. And these are just the list of documents that needs to be completed. These are all available on our website. But if you do the online application, you will be prompted to complete the correct documents. The documents will be auto-completed as you capture the details, and you can merely print and sign them at the end of the application. So it will not be necessary for you to have these hard copy documents or find them somewhere, because they're all available online. Okay, so like I indicated, after the appointment, the person must still administer the estate in terms of your will, or if there's no will, the intestate succession, but it does not need to lodge an account. When the estate is more than 250,000, the master appoints an executor. Now, the documents to be completed is more or less the same, except that the person might be requested to lodge security to the full value of the assets, unless he has been exempted from security or is the spouse or child of the deceased, or the parent of the deceased. Now, if you did not leave a will, and like I indicated, the estate will then devolve into estate. However, if you don't leave a will, you are leaving the appointment of your executor or the administrator of your estate up to your heirs. They will then have to nominate amongst themselves someone that needs to do this. Whilst if you have a will, you can in that will indicate who you want to, someone that you trust, someone that you know will be able to do it, someone that you know will be fair and look after the interest of your children. You can indicate who you want to be executor, and you can also indicate whether that person needs to give security to the value of your assets or not. All right, so after the appointment of the executor, there are certain statutory duties that this person will have to do. Advertising of account in the Government Gazette and local newspapers, advertising for creditors, and the executor has 6 months from his date of appointment to get everything in order so that he can lodge the liquidation and distribution account with the master for examination. Now, you're wondering what extra costs there might be involved. In an estate less than 250,000, there's no fee payable to the master. In an estate more than 250,000 Rand, there's a master's fee, which starts at 600 Rand, depending on the value of the estate. And that's a maximum of 7,500 Rand. It's paid into the Justice Bank account, so it's not given to any master's official or anyone like that. And then there's also, in terms of the Act, executor's fee, which is a maximum of 3.5% of the value of the assets, plus VAT if the person is registered with VAT. However, again, if you have a will, you can in your will indicate that your executor is entitled to a lower fee instead of the 3.5%. However, if you leave it to the heirs to nominate someone, that person might probably charge the full executor's fee. Then the other copies, the other thing that there might be a need to pay for is copies of any documents in your file, which is 25 Rand, sorry, for normal, or 50 Rand for certified copies. And that is the fee involved with regards to the master with a deceased estate. So no master's official may ask you to pay him or her personally any fee for performing his or her duty, whether it is to register the estate, to examine the account, or anything. These are the only fees that's payable to the master. All right. Okay, so what should we remember in a deceased estate? Anyone can inherit, but all debts of a deceased need to be paid. So before they can inherit, you need to pay your debts. If you had a bond over your house, then that bond needs to be paid off before anyone can inherit the house. If there's not enough cash, assets needs to be sold to pay all the debts, and then what's left can be inherited by the heirs. You cannot inherit debt. So if there are no assets and there was only debt, then normally that is either then done as an insolvent estate, or the creditors will needs to write it off, because no one can inherit debt. The other thing you must remember, the person that the master appoints is not necessarily the heir. The master does not appoint the heir to the estate. He appoints someone to administer your estate. The heir is determined by you in your will, or if you did not leave a will, by the Interstate Succession Act. So I did some things here on a will. I'm quickly going to go through them because I don't want to steal the show of the other presentation, but a will is also known as a testament, and it basically sets out what must happen to your estate. You nominate, like I said, your executor. You can create a trust. You can nominate trustees, and you can also appoint guardians for your minor children or for the assets of the minor children. The next slides I'm just quickly going to skip over because this is going to be dealt with by another presenter. But what I can say is, upon death, the will needs to be lodged with the master, the original will, and the master will then determine whether it is valid or not. If the master says it's invalid, the family can apply to the High Court to have it declared valid, but he who alleges must prove. So if you, for instance, did not sign it or some other reason, you can still apply to court, but it's for the cost of that person that applies. The same when the master says it's valid, you can apply to court to have it declared invalid on various grounds, depending on why you are of the opinion that the person did not really draft the will. So what happens if I don't have a will? Your heirs are determined by the Interstate Succession Act. They decide who must be the executor, and they can even decide who will be looking after your minor child, and the funds due to the minor will be deposited into the guardian's fund. We need to remember that in a case of marriage in community of property, both spouses' assets are being dealt with in the deceased estate, but the surviving spouse will receive half of it already due to marriage, and the rest will then devolve either interstate or in terms of your will. So if you do not leave a will, it can happen that your second spouse inherit the family house to the exclusion of your children. So when you pass away and leave your husband and he marries again, it might be that his new wife will inherit his assets, especially if he doesn't leave a will again and he married in community of property. Okay. So this is just the basic interstate succession. Where there's only a spouse, the spouse will inherit everything, but where there's a spouse and children, Like I said, with a marriage in community, the spouse will get half, and then 250,000 or a child share, whichever is the greater. A child share is determined by, if there's 2 kids, it's 2 plus 1 for the spouse, so you divide the estate by 3, and then there's a child share. Grandchildren might inherit if they are predeceased children. If you had no spouse and no children, then we look at the parents or the uncles, aunts, nephews, and so forth. And like I said, in case of a marriage in community of property. The Black Administration Act has been repealed. It has been declared unconstitutional, sorry. So since 6 December 2002, the Master's Office is doing all estates, not only those of white people or people with wills, but all estates. The gist of this that should be remembered is that all estates that was registered or dealt with by the Magistrate's Office under the Black Administration Act. So those are your old estates of Black people, your grandfather and so forth, maybe, that passed away prior to 2002, still needs to be dealt with by the Magistrate's Office and finalized by them. So unfortunately, you cannot come to the Master and request the Master to assist you where there's been wrongdoing in one of those estates. The Magistrate's Court, where it has been registered, will have to assist you. However, if that estate has never been reported at the Magistrate's Office, in that case, you can report it at the Master's Office. I'm not going to go into customary marriages because there's going to be a presentation on that as well. I can maybe just mention that partners in a permanent life partnership, the definition of spouse have been extended to now include these people also as spouse in terms of the Maintenance Act and in terms of the Interstate Succession Act. But they must have had a reciprocal support duty. For it needs to have been permanent, and they have to have undertaken that duty of support. So, but that was since 1 July 2023. But these are some factors that the Master will look at when establishing whether there is such a permanent life partnership, whether there was ceremony, the ages, all kinds of things like this. We have a form, NBU 19, which can be completed. It's an affidavit form which asks you all these questions. But the spouses in this instance must have been able to contract a legal marriage. So you cannot have been married or still be married to someone, then maybe just estranged, and then you start living with someone else for many years maybe, but that person is then not a permanent life partner because you could not have married them. You are still married to someone else. So that's important to know. Also, if there is any fight about whether, or disagreement amongst the heirs on whether or not this person was really the permanent life partner, then only the court can rule on whether that person should be deemed as the spouse for the interstate succession. So it will be better if you are in such a relationship to make sure that you legalize your arrangement. Or if you draft a will, you can make your heirs whoever you want to, and you can make that person then your sole heir to the exclusion of your estranged spouse if you have not been married in community of property. So that is what I have to say to you today. And thank you very much for listening to me.
Thank you, Ms. Venter, for that detailed presentation made by yourself regarding the administration of estates. And I'm sure there is a lot of questions. If you go to the Q&A, you will see there's already 4 questions or remarks or comments that have been made. And we encourage you to ask what you need to ask at the end of the day. Our next speaker is Ms. H. Hendricks from Legal Aid South Africa. And Ms. Hendricks will be dealing with the importance of having a will. Ms. Hendricks' biography is as follows. Ms. Hendricks is admitted as an attorney and conveyancer and currently holds the position of National Legal Manager, Civil and Legal Aid South Africa. She has a long career in Legal Aid South Africa and have always worked towards empowering citizens about their rights and to ensure that they have legal representation when they need to enforce their rights. Honisa, Ms. Hendricks started her career as a candidate attorney with Legal Aid South Africa and has appeared and represented clients across various courts. She is passionate about the law of succession and ensuring that citizens know how to protect the assets and what measures to take to ensure that the assets devolve as intended after they pass on. Ms. Hendricks is involved in preparing candidate attorneys on succession so that when they are in practice, they are able to assist clients in the drawing of wills and the administration of estates. Legal Aid South Africa provides legal representation services in deceased estates where minor children are beneficiaries. I now hand over to Ms. Hendricks to do her presentation. Thank you.
As Ms. Daniels has said, I work for Legal Aid South Africa. I work with deceased estates, and I work very often with matters where we see the impact of not having a will. So today, my discussion focuses on the importance of having a last will and testament. So in terms of my presentation, we will talk a little bit about why we need a will. What is a will? The legal requirements for a valid will. And then lastly, where would I keep my will? Okay. So the first one is, what is a will? So the will is a document that tells the world what you want to have happen with your assets once you've passed away. So it gives direction to those that you leave behind in terms of what is it that you wanted to have happened with your assets. In your will, you can appoint an executor, as Ms. Venter said, and the law says that the executor must then administer the estate based on what you said in your will. So, as we mentioned earlier, if you do not have a will, your estate will devolve in terms of intestate succession. So, intestate succession means that there's an act, legislation that determines what happens when you die and you do not have a will. So that is intestate succession. The law will tell you what will happen to your assets. But if you want to make a decision about your assets, the way to do it is by executing a will. Then you tell the world, as well as the people you left behind, what you want to have happen with your assets. So your assets would include money. Investments, savings monies that you have. It would include things like cars. It would include immovable property, any assets that you leave behind, whether it is, sometimes people ask us, but I have nothing. But what they actually mean is, I don't have a house. So assets is not only an immovable property, it's anything that you have. So in your will, you can give direction of what you want to have happen to your assets. As I just as to advise participants or people watching, at the bottom of each of our slides, I have the legal aid advice line number. So the first number you see is a landline number, and the second number you see is a please call me number. So that number you can call, and you can get legal advice when you call that number. If you do not have access to a landline, you can send a please call me and we will call you back. So the legal advice line can be contacted to get any legal advice, right? So when you see that number at the bottom of the screen, that is the legal aid advice line. So coming back to the discussion of a will. So just to recap, so the will is a document where you tell the world what you want to have happen with your assets. And as I've said, assets doesn't mean you have to have 5 houses, or a big house, a small house. It means any assets that you have. And now the question, why should I have a will, right? A will gives you an opportunity to decide what you want to see happen, right? As I said, if you don't decide, then legislation determines that it will devolve in terms of intestate succession. So the will gives you that opportunity to say to the world what you want to have happen. It helps to eliminate any conflict. Very often we see people come in and say, yes, but my father wanted this, or my mother wanted this, or my sister wanted this, right? But if you leave a will, no one will be uncertain about what you want. It will be in your will. You would have told them, this is what must happen to my assets. So it helps eliminate the conflicts that we often see happen. And then a will also gives you an opportunity to put measures in place for especially your minor children. You might want to put measures in place for other people as well, but especially minor children. So you have the opportunity to say, who must look after my children? What monies must go to my children? As Ms. Venter mentioned, whether there must be a trust, whether there shouldn't be a trust. Or whether, even if you choose that the money should be paid into the Guardian Fund, whether that should be done. If you choose that anything you left for them should be taken care of in a particular manner, then that is what you put into the will. Just a caution in terms of what you put into the will, take into account that you do not make it too onerous. And also, it is advisable to discuss with the persons that you, for example, want to appoint as trustees, want to appoint as guardians, to discuss that with them before you put it in your will, because you do not want to appoint someone that doesn't want to take that responsibility. You want to appoint somebody that you know you can trust to take care of your children and take care of their assets to the benefit of your children. So do discuss what you want to put in your will with those people that you want to put in charge, if I may say so. For example, the executors. Discuss this with them. It is an important a job to do. As Ms. Venter has mentioned, there's certain legal requirements that is applicable and that must be complied with by the executor. So choose somebody that is responsible, choose somebody that you can trust, and discuss this with that person. Do not let it be a surprise that they were appointed as an executor, that they were appointed as a guardian, or that they were appointed as a trustee for the assets of your children. Be open with whoever you appoint in your will, but a will does give you an opportunity to make those decisions. Further, it, as mentioned, it provides clarity and certainty about what you wanted. And so you see that issues that family normally has, it is eliminated when there's a will. No need to go to court for fight about what mother or father would have wanted. The will sets it out. It is clear and certain. It also gives you an opportunity to provide for anyone you wanted to provide for. It doesn't, even if it's not family, but it's somebody that you've taken in and you've cared for, you can then in your will say that you want to provide for that someone. If it is an organization that is dear to your heart, so an organization that you want to give a donation to, a will gives you an opportunity. If you do not have a will, as we've mentioned, legislation will determine how your estate will devolve. And legislation will focus on people that are blood relations. So if you want to make provision for somebody that is not linked to you in terms of blood relation, family, an organization, or any other person, then the will is a way to do that, to provide for that person or to give acknowledgement, a donation to that organization. it also gives you an opportunity to do estate planning. And this is something I love about a will and explaining this to clients and families. Estate planning is about looking at what you have and who do you want to leave it for. But when you look at what you have, you might have an immovable property and there's still a liability on that property, meaning there's a bond attached to that property. So if you pass on and the bond is still there, you now have an opportunity to think about, now, how will that bond be paid? What can I do to ensure that my children is not encumbered by needing to either pay the bond or by needing to sell, the executor needing to sell the assets in order to pay the liability. So that is what a will also does. It allows you to think about your estate planning, even if it isn't the liability in terms of a house, even if it's just general liabilities that you have. You now have an opportunity to think, how will I make provision for paying those debts that we might have, that you might have when you pass on? So for example, people can take out a policy of a certain amount. They determine at any point in time that this is the liabilities I have. They take out a policy and that policy pays into the estate to cover some of the liabilities. So that is what a will also does for you. It allows you to do some estate planning. And often, this is not the purpose of a will, but often when we do and execute a will, it also just reminds us to do that estate planning, to work towards being, debt-free, so that when we pass on and we leave assets to our children, it is less incumbent than what it would have been if we did no planning at all. So in terms of making sure your will is valid, you must be older than 16, you must be 16 years and older to execute a will, right? The will must be in writing. So this is something I just want to focus on a little bit. I know that we now live in a world of electronics and everything happens online. So our courts have found in some instances that where there was an electronic will that was found, that the court accepted it to be the last will and testament of a deceased. But that is after going to court. You want to make sure that people do not have to go to court. Legislation still says it must be in writing, and until legislation has changed, we need to comply and make it easier for the people that's left behind, and therefore make sure that your will is in writing. The will must be signed by the testator on each page. Then, where a testator makes a mark or asks someone else to sign the will for them, then there must be a commissioner that certifies that this is indeed the mark of the testator, or that this person is directed by the testator to sign the will. The purpose of the commissioner is to ensure that this is indeed your will and testament. The contents of that document is what you want to have happen. And so therefore, when there is a will that a person cannot read and write, then they make a sign, or they get someone else to sign for them, it is important, or not only important, it is a requirement to have a commissioner. If there is no such commissioner and the will was done with a mark and a commissioner did not append its certificate there, that will can be challenged as not being valid. The master is a creature of statute, so it will look at what the requirements are, and it will say that this is not a valid will. Again, someone will have to go to court, and someone will have to try and convince the court that this is a valid will. Like I said, we want to avoid having to go to court, so we rather need to make sure that the will meets the requirements of legislation as it stands now. So in further requirements are that there must be witnesses. So 2 or more witnesses, competent witnesses. So the Act says competent witnesses are people that are 14 years and older and that have not been found incompetent to testify in a court of law. Now the witnesses only need to sign at the end of the will. If, for example, they sign all pages, that doesn't matter, but they must sign at the end of the will. as said already, the testator must sign each page. The commissioner must sign where the certificate is appended, as well as each of the other pages if the will is more than one page. Now, the signature of the testator, the signatures of the witnesses must all happen in front of each other, right? So this means that a testator signs in front of the witnesses sign in front of the testator. Just think about it. The witnesses are witnessing that this person is executing the will. So they need to see that this person is signing the will in their presence, right? So it is important. We have seen matters where people, for example, execute a will and send it to other people, and people witnesses the will, but the testator is not there present to sign it or confirm that this is in fact my signature. Such a witnessing would not meet the requirements. Again, we rather want to meet the requirements than having to go to court to ask the court to say this is okay, because that would cost money and time. Now, in terms of the safekeeping of a will, make sure that your will is kept where your important documents are. So your important documents like passports, ID documents, marriage certificates, divorce orders, those types of documents. Make sure that people know where this is, the people that you trust, and especially the executor knows. You can even make a copy for your executor and tell the executor where the original will is, because as said earlier, what must be submitted to the master is the original will. So once you've executed your will, keep it in a safe place. Tell the executor where the will is. Where you have minor children, you've appointed a guardian and trustees, tell them where your original will is so that they can retrieve that when you pass away. Tell your wife, your spouse, where the will is so that they can easily retrieve these things when you do pass away. And that concludes my presentation on the importance of a will. Like I said, Legal Aid South Africa has a legal aid advice line. The advice line you can call anytime, and the numbers are again on your screen. We can also be found on social media. You will see it on your screen. But so, you know, sometimes when we listen to presentations, it's something that sticks in your mind, something you might have forgotten, something you still wanted to ask. Now, that's the time that you can use that numbers that's on your screen. The top one is a landline, the 0800 110 110. That's the landline. You can call it. It's toll free. The second number is a please call me number, where you send us a please call me and we will call you back. And you can ask us anything about wills, what happens, the administration of estate, or even any other legal advice that you need. You'll get that free of charge if you call our numbers. Thank you, Ms. Daniels.
Thank you, Ms. Hendricks, for that very detailed presentation relating to the importance of wills, as well as the services rendered by legal aid, as well as what a will needs to comply with in order for it to be accepted by the Master of the High Court. I can already see that these questions that has been posed on the Q&A, which we will attend to after the presentations have been done. The next presenter is Ms. A. Botha from Legislative Development of the Department of Justice, and she will speak to us about registration of marriage regimes and how they impact the administration of deceased estates. Now, Ms. Botha's biography is as follows. Ms. Alison Botha is a state law advisor in the Chief Directorate, Legislative Development and Implementation in the Department of Justice and Constitutional Development. She is responsible for, amongst others, the processing of the Divorce Amendment Bill 2023, which extended to the protections of the Divorce Act 1979 to Muslim women and children on the dissolution of Muslim marriages. She is an admitted attorney with 10 years of experience in both the private and the public sector and has an interest in various aspects of public law, including constitutional and administrative law, refugee law, international law, land reform and land restitution, and the intersection of policy and legislation. She holds an LLB from UKZN and an LLM from UCT. I now hand over to Ms. Botha to do her presentation. Thank you.
Thank you very much, Ms. Daniels, for that introduction. Good afternoon, everyone. Like Ms. Daniels has said, I will be presenting today on matrimonial property regimes and what that means for the administration of deceased estates. Just start my presentation. So, the registration of marriage regimes and how they impact on the administration of deceased estates. What the purpose of this presentation is, and why this is an important consideration, is that the legal implications of your marital property regime affect the treatment of assets should your marriage be dissolved through death. So before drafting your will, it's important to understand how your marital property system affects your property rights and your ability to distribute your assets. So your marital status, previous marital status, and current marital property regime can have really far-reaching estate administration consequences. So what is a matrimonial property regime? It's guided by the Matrimonial Property Act of 1984, and that's a piece of legislation which is administered by the Department of Justice and Constitutional Development. It's significant legislation, and it determines how assets and liabilities are dealt with between spouses in their marriage and how these are dealt with afterward. The chosen marriage regime has legal consequences for the spouses, and that include the dissolution of the marriage by, for example, divorce, the death of one or more or both of the spouses, the incurrence of debt and insolvency, the sale of immovable property, and it requires you to choose what to do with the assets you own and the debts that you incur before and during your marriage. So who does the MPA apply to? And the MPA stands for Matrimonial Property Act. So the MPA will apply to every marriage. That is, once your marriage meets the requirements set out in the legislation according to which you are married, and it's recognized as a valid marriage. So the MPA applies to a marriage in terms of the Marriage Act of 1961, a civil union in terms of the Civil Union Act 2006, and a customary marriage in terms of the Recognition of Customary Marriages Act 1998, the RCMA. And in particular, Section 7 of the RCMA refers to the MPA. But it's also important to note that in terms of customary marriages, Section 7 of the RCMA governs the proprietary consequences of those marriages. So what are the types of matrimonial property regimes in South Africa? There are two main types, and you will have heard these in passing bandied about. And the two main types are marriage in community of property and marriage out of community of property. And within marriages out of community of property, there are two different subsets, being with accrual and without accrual. Is it possible to change your regime after marriage? It is. Although it's important to take your matrimonial property regime into account before you're married, it can be changed in terms of Section 21 of the MPA. And it's in accordance with the requirements set in Section 7 of the RCMA for customary marriages. But if you want to change your matrimonial property regime after you are married, it has financial consequences because Section 21 of the NPA requires you to make an application to the court setting out certain factors which show the court that the matrimonial properties regime can be changed. So a marriage in community of property, what does it mean? Means that all assets and liabilities accumulated by either spouse before or during the marriage are jointly owned, and they form part of the joint estate. Any debts or financial obligations incurred by one spouse also become the responsibility of the other spouse, whether that debt was incurred before or during the marriage. So this means that if your spouse incurs a debt and they can't repay it, you might be required to repay that debt. Each spouse has the capacity to bind the joint estate through their actions, and each can equally manage the joint estate. But there are instances where a spouse must first obtain the consent of the other spouse before they can bind the joint estate. In many instances, the consent of the other spouse is not required. But there are instances where a spouse must first obtain the consent of the other spouse before they can bind the communal estate. And that consent can either be oral or written, depending on what's required in law. So, for example, you need your spouse's permission to take out credit or a home loan, to sell a large asset like a movable property, or to stand surety for a loan. In South Africa, a marriage is automatically assumed to be in community of property, and that is the default position, unless you enter into an antenuptial contract or an ANC. If an ANC is not entered into before the date of the marriage, the matrimonial property regime is automatically in community of property. Now, for marriages out of community of property, they involve an ANC, and that's an agreement you enter into before your marriage, where community of profit and loss are excluded. And it needs to meet certain stipulated formats and formalities in order for it to be a valid ANC. There is no joining of the spouse's estates for marriages out of community of property. So each spouse has their own separate estate consisting of their assets and their debts acquired before and during the marriage. Like I said earlier, you can enter into two different types of ANC. An ANC that excludes community of property, community of profit and loss, and the accrual system. So you're married out of community of property without accrual, or an ANC that excludes community of property and community of profit and loss, but includes the accrual system. So out of community of property with accrual. An accrual is essentially the amount by which the spouse's joint wealth has increased over the period of the marriage. For marriages out of community of property without accrual, in this system, each spouse keeps their separate estate, whatever assets and liabilities they had before and which they acquired during the marriage form part of their separate estates. This system gives each spouse absolute independence of contractual capacity and protects each spouse's estate against claims by the other spouse's creditors. You don't need your spouse's consent to take out any credit, purchase a house or a vehicle, and you're not liable for your spouse's debts unless you've stood surety for them. The accrual system must be expressly included in the ANC, otherwise it automatically applies in terms of the NPA. So for marriages of community of property without accrual, they are often more juristically equal because spouses can each deal with their assets as they please, but it may lead to financial inequality because the economically weaker spouse doesn't get a share in the estate of the stronger spouse, even though they may have contributed directly to the estate. But there is something called a redistribution remedy on dissolution out of community of property marriages, on divorce in terms of Section 7.3 of the Divorce Act of 1979. And now there has been a recent Constitutional Court judgment in EB, and the citation is there, and that came out in October last year, and that extends the scope of application of that redistribution remedy to marriages out of community of property which are dissolved by death as well. So for marriages out of community of property with accrual, that provides for an equal sharing of the profits, the accrual, made by parties during the subsistence of the marriage, and assets which the spouses had before the marriage can be included or excluded in the accrual. The net value of the assets of each of the spouses is declared in their ANC, and should there be no assets or commencement value of the two estates specified in the ANC, it's deemed that the value of the estates at the commencement of the marriage be nil. Each spouse can keep their separate estate during the course of the marriage, but can share in the growth of each other's during the marriage. Certain assets are excluded from the accrual calculation. For example, they're not taken into consideration at commencement or dissolution. Now, matrimonial property regimes and deceased estates. So how assets will be distributed after death is a crucial consideration for everyone. When a person dies, their assets will be distributed in terms of their will, testate succession, or if they have not left a will, according to the rules of interstate succession in terms of the Interstate Succession Act. In South Africa, there's freedom of testation, and that means that you can leave your assets to whoever you like, although this is not an unfettered right. But this can be affected by your chosen matrimonial property regime. So your regime must be taken into consideration during your estate planning process to ensure that your will is aligned with the rights and obligations that flow as a consequence of your chosen regime. For marriages in community of property and deceased estates, there is a single estate, the joint estate, and upon the death of the first dying spouse, the whole estate must be wound up. The executor will have to wind up the entire estate on the basis that there can be no joint estate if there is only one living spouse. In the event that you are the first dying spouse, your executor will be required to settle all the debts in your joint estate, including debt which was incurred before the marriage. The only debts which don't form part of their joint estate are funeral costs and estate duty, because those are payable by the deceased only, and they're calculated and deducted before the distribution of the deceased's 50% share of the joint estate. Both spouses are jointly liable for the debt incurred before and during the marriage. Only after the executor has settled all the debt in the estate can the surviving spouse have a claim for 50% of the net value of the joint estate. The remaining 50% share will be distributed in accordance with the first dying spouse's will, or in terms of the laws of interstate succession if there's no will. So it's important for those drafting a will, if you're married in community of property, to consider that your will should only deal with your 50% of the joint estate. Because if you're married in community of property, you can only bequeath 50% of the joint estate because the other 50% belongs to the other spouse. Bequeathing jointly owned estates to a third party can result in complexities and unintended consequences. For instance, if a testator bequeaths their share of the primary residence to their only child, a situation may arise where the property must be sold in order to pay that child their inheritance. It's also important to note that bank accounts held by the deceased and joint accounts held by both spouses can be frozen once the bank receives the death certificate, which means that funds cannot be withdrawn and debit orders debited. But the executor can apply to the Master of the High Court to release funds for the maintenance of the surviving spouse. Marriages out of community of property without accrual and deceased estates. This is the most simplistic regime when it comes to the administration of deceased estates because there's no accrual claim and spouses can dispose of their assets as they deem fit. So on the death of the first dying spouse, their estate will be administered by the executor with no impact on the estate of the surviving spouse. The deceased spouse's estate assumes full responsibility for the debt in that estate, and the creditors will have no claim against the surviving spouse's estate. So only the estate of the deceased is wound up. The assets of the deceased spouse will be distributed in accordance with their will or in terms of interstate succession law. So for marriage of community of property without accrual, continued, if the surviving spouse has a claim against the deceased estate, such as an outstanding loan, they must claim with the executor of that deceased estate, like any other creditor. If the surviving spouse is left with insufficient support, they can institute a claim under the Maintenance of Surviving Spouses Act of 1990. If the first dying spouse fails to make adequate provision for the surviving spouse may have a claim for reasonable maintenance from the deceased estate, to the extent that they are unable to meet those needs with their own means or their own earnings. In general, a maintenance claim of this type is settled by way of a lump sum payment from the deceased estate, and a surviving spouse's claim for maintenance falls within the same order of preference as child's claim for maintenance. Now for marriage of community of property without accrual and deceased estates continued. Like I alluded to earlier, there's now a redistribution remedy in terms of the Constitutional Court judgment in KG and EB for out-of-community of property marriages dissolved by death. It's important to note that if the primary residence is owned by the first dying spouse, the surviving spouse may find themselves without accommodation if the deceased bequeaths the property to a third party. And each spouse should have some insight into what their financial position would look like should the other pass away. Now for marriage of community of property with accrual. The nature of the accrual is that each spouse maintains a separate estate for the duration of the marriage. And when the marriage is dissolved, either through death or divorce, the accrual system comes into effect. Each spouse gets to share equally in the growth of the two estates calculated from the date of the marriage. So upon the death of the first dying spouse, their estate will be subject to estate administration, and the executors will have to calculate the accrual. So on the death of the first dying spouse, the increase in the real value of the spouse's respective estate will be added up and divided by 2. So the net value of each estate is calculated, and the spouse with the larger estate must transfer half of the difference to the spouse with the smaller estate. If the estate of the first dying spouse has the greater accrual, the surviving spouse will have a claim against the deceased estate. But if the surviving spouse has the greater accrual, the deceased estate will have the claim against the surviving spouse. So where the first dying spouse has the larger estate, the surviving spouse's accrual claim will be a preferred claim, meaning that it must be paid before any portion of the deceased spouse's estate is distributed. So if the surviving spouse has greater accrual and is the sole heir in terms of the will of the deceased or in terms of interstate succession, the accrual will not cause a liquidity shortfall because the surviving spouse will inherit everything anyway. But it could become problematic where part of or the entire estate is bequeathed to a third party, and the surviving spouse doesn't have sufficient funds to settle the claim against them. If the first dying spouse's estate is smaller, his estate will have a claim against the surviving spouse for a share of the accrual, which could result in the surviving spouse being forced to realize assets to settle the debt. Another thing to be borne in mind is estate duty in matrimonial property regimes. The matrimonial property regime under which the deceased person was married will impact the calculation of the estate duty. Where the accrual system applies to a marriage out of community of property, the spouse with the smallest accrual will have a claim against the other spouse. For marriages in community of property, the value of the surviving spouse's estate is calculated after liabilities and administration costs have been deducted from the joint estate, and funeral costs and estate duty are paid from the deceased half of the estate after the joint estate has been divided. And this is important because a spouse for estate duty purposes is a marriage or customary union recognized in the Republic, unions recognized as marriages under the tenets of religion, or a same-sex or heterosexual union, which the Commissioner of SARS is satisfied is intended to be permanent. In conclusion, your marital regime can have unintended consequences for your surviving spouse, and it requires careful consideration when you're drawing up a will. Estate planning can be complex, and failing to understand the consequences of your chosen matrimonial property regime on your estate can have unintended consequences for those you leave behind. So one of the greatest gifts you can leave behind is a well-structured estate plan supported by a valid will. Thank you very much, Ms. Daniel.
Thank you, Ms. Botha, for that detailed presentation relating to the marriage regimes that we have in South Africa. And I'm sure it has made us think about even before you enter into marriage as to what regime is applicable to you, or what would you want to be applicable to you. Now we have now moved on to our Q&A session, where it would appear that there is at least either 11 questions or comments or remarks made. So I will now move on to the Q&A session, and we will read out the questions, and it will be allocated to the panelists in order for them to answer same. So the first question is, how does one access documents from the Master of the High Court? If an error was made in a final settlement, how does one verify a request for repayment? What documents must be supplied by the executor who made the error? So the steps that we will be following is that we will take 5 questions at a time, and some will be answered. I think that would be in the domain of Ms. Venter, because it relates to the Administration of Estates Act. The second question that was posed is, as trustees, we also encounter a big challenge with properties which are said to belong to tribal authorities or villages, as they are said not to belong to SA registered land and regulations. The challenge is that we might lose a lot of plots and or land that is acknowledged in the will by the deceased to inherit, as there is no legal representation to assist in this regards, and the tribal officers' procedure are not regulated and or not having records in place at the time to register and monitor properties and land. How can we get assistance in tracing and claiming such properties? Now, I'm not sure which of the panelists will be prepared to answer that question, so I will leave that one open. The third question is, if the deceased, after divorce, got married and the title deed for a house or property is still registered under the first spouse, whom the deceased divorced, what rights does the surviving ex-spouse have on the house or property? There was no will, even for the second marriage. The fourth question is again from the same person, and it's directed to Ms. Venter. Ms. H. Venter, in our case, the claimant was submitted on that 21st day's grace period after advertising the deceased estate. Then the claimant submitted such fraudulent papers, and the attorney or executors accepted such fraudulent claims, and the people continued occupying the properties unlawfully. They do not want to assist as litigation is expensive, and they cannot intervene as it is on tribal authority. What can assist further except the tribal authorities? Please advise. And the last question for this round is, my sincere apologies for the late joining you late. My question is from the point of view that many If not, some of our parents are traditional in making a will or equally disseminating the assets to their children while they are still alive, so as to not cause conflict within their children. How does the justice system help in the event that both parents pass away without leaving everything to their children's discretion? Both parents passed away without a will, and out of right children, only 3 of us remain, and accounts need to be paid. The property is still in their name. How do we resolve any issues that they were party to prior to passing on? So these are the first 5 questions that I will be giving to the panelists, if they are please able to respond thereto. So I'll hand over to the panelists to answer. Thank you.
Thank you, Ms. Daniels. I think maybe I will start because it seems that most of these questions are actually related to deceased estates, but any of the other panelists are more than welcome to also join and give their input. The first question, how does one access documents from the master's office if an error was made in the final settlement? How does one verify a request for repayment? What documents must be supplied by the executor who made the error? Okay, I presume that in this case there was a liquidation and distribution account lodged with the master, which should have been advertised for inspection by the interested parties who could have viewed it and then objected to the master. If that period has expired without you objecting to that incorrect payment or incorrect claim, then unfortunately you will have to apply to court for that claim to be accepted. But if the estate has already been divided, then you will have to institute action against the heirs of that or the people who received the incorrect payment. The next one is a difficult one. I am not much au fait with tribal issues. Safe to say, it says that we also encounter a challenge with properties that belong to tribal authorities or villages that are not belonging to South Africa registered land and regulations. So as far as I have it, but really anyone can correct me here, Ms. Hendricks or Ms. Botha or Ms. Daniels, tribal land is not an estate asset which you can indicate in your will who should inherit it or who should get it. Only the tribal head can do that because it's basically a living right that you have on it. So unfortunately, there's not much I can say on this. The best would be to get a legal representative to assist you and to take that forward. If the deceased after divorce got married and the title deed is still registered under the first spouse, what right does the surviving ex-spouse have on the household property? It will depend on what your divorce order said, who is getting what. If the 2 spouses were sharing this property, so it's still in both their names, then when one of them passes away and they are divorced, the other ex-spouse does not have a right to that divorced spouse half share. The half share of the divorced spouse will of the deceased ex-spouse will devolve in terms of either the valid will or intestate succession to whoever there is then are. If it has not been divided yet, if you mean that it still has to be divided and then the one passed away, that process needs to be followed, and the executor of the deceased estate needs to make sure that whatever was agreed upon in the settlement agreement is complied with before the estate is being distributed. the claim that was submitted within the period of advertisement, if it was not accepted by the executor, unfortunately, okay, there's two things you can do. You can either object against the account, but if it's a factual dispute, the master will refer you to the court to get a court order declaring either the claim valid or invalid, depending on the circumstances. Oh, this one, yes. The Interstate Succession Act is applicable on the estates of all South Africans, irrelevant your race, color, gender, religious belief, or whatever. If you do not leave a valid will, the Interstate Succession Act is applicable. So, as indicated by Ms. Hendricks, a will needs to be in writing, it needs to be signed, and so forth. So, unfortunately, parents telling kids to take certain things is, I mean, even my parents did it. And then the moment they pass away, then the children start fighting about this. Is not the way to go. Rather do it in a will, a valid will, indicate exactly who you want to get what. It's a bit more difficult when it's, for instance, assets like, you know, my mom's Royal Albert should go to the sister and the couches should go to someone else. But if there's any possibility that the children will fight about this, it is best to put it in your will in writing, even if you have to say the couch goes to X and the tea set goes to Y. Because should they pass away without a will, and those assets has not been transferred to the children they wanted to have received during their lifetime, it will devolve in terms of the Interstate Succession Act, which will mean that depending on what the situation is, the surviving spouse will get a share and the children will share equally in the remaining part. That is a very short answer to a very difficult question, but unfortunately, that is the way it is. So if you prefer that your assets devolve in terms of traditional law, you should indicate that in your will and ensure that it is indicated, or after your death, it is divided accordingly. Okay, I think that is the first questions. I've actually touched on all of them. I do not know if any of the other panel members wants to add something. Thanks.
Thank you, Ms. Venter. I invite the other panel members if they wish to give more inputs. If not, we will then go to the next 5 questions. Thank you.
Thank you, Ms. Daniels. I just want to re-emphasize what she just said now. With regard to the tribal authorities and tribal lands do not belong to, are not properties or assets that can be included in the distributions or in a will. She is correct that any issues that have to deal with tribal land has to be resolved through the tribal authorities. I'm afraid that I see the question coming again, and it might be one of those that one can offer the services of being contacted after the session so that I can take through the person who asked the question. Thank you.
Thank you, Ms. Rangata, for that. Any others? Okay, it would seem that we are moving to the next 5 questions. The next 5 questions. The 21 days turnaround time for letters of executorship to be issued is not what happens in practice. It takes months. Recently, it took 5 months from the Master's office in Cape Town. Then we go to the bank to open the estate late account, and the bank used to take 5 to 7 working days to vet the documents. But now that also takes months because Master's office needs to give the banks the assurance that the documents are in order. What is being done to speed up the process in the Master's offices? That's the first question. The second question is, regarding the above, the bank is asking the deceased extended family to pay the estate security to them, which is not possible and will not happen. Prior to death, I was appointed to administer the family affairs of the deceased by her family. The third question is, how many trustees should be on the trust fund? Can an executor be the trustee at the same time, or should they be lawyers nominated? And then the next question, the ex-spouse, husband died without a will and no kids with new spouse. The title deed we extracted from deeds after burial a few weeks back lists ex-spouse as co-registered owner and not the current surviving spouse. What legal rights applicable by the ex-spouse and the current spouse as they were married in community of property? And then the last question, indigent households are unable to get assistance at legal aid with administration of deceased estates when they need services of a conveyancer. How can this be addressed? So I hand over to the panelists in order for them to be able to answer the questions posed. Thank you.
Thank you, Ms. Daniels. I think I have to answer everything basically except the Legal Aid South Africa question, which Ms. Hendricks can assist with. But please, again, after I've answered my colleagues, please add. Okay, with regards to the 21-day turnaround time, you must keep in mind that, first of all, the turnaround time is when the master has received everything in order. So all the documents need to be lodged. There should not be any outstanding requirements. And then the target we have on there is 75%, which means that 25% of our estates will take longer to issue the appointment letter. However, currently, when we are, as I explained, we have the online administration of estates registration system. So as you register the estate and you lodge it, you immediately get your estate reference number. Then part of this is also that when the master approves it, the appointment letter that's being issued is received by the executors same time. When the assistant master presses approve, it immediately sends an SMS and email to the executor with attached thereto the QR coded appointment letter. So there's no need anymore for anyone to go collect an appointment letter or wait for it in the postal services, which is not working, or anything like that. Also, there's no need for the bank anymore to contact the master's office to verify it, because they merely scan the QR code and they can, from the QR code, then determine whether it is a valid appointment or not. So in that regard, these are the things that have been implemented in order to speed up the processes and alleviate frustrations experienced by public. Brigitte Banda, with regards to the bank asking you to pay the estate security, that is totally improper. I do not understand why they would request you that. Furthermore, it's very strange that if there's a will, that there is actually security to be paid, because normally in a will, the executor is exempted from providing security. So I am not sure what's going on there and what happened there, but to me it does not sound correct. Or maybe they were misunderstood. It's something else that you had to pay in and not the security, because security is normally like a policy they take out that runs over the period of the administration of estates. Okay, sorry about the motorbike. Then, how many trustees should be on the trust fund? I think you mean in a trust. A trust fund is something totally different than a trust, but I think, Zandile, that you meant in a trust. Normally, there should be at least more than one, because otherwise this person has got free range on everything. But there isn't a minimum and there isn't a maximum. That is determined by the founder of the trust because it is a private contract and it's something that they can decide on. However, if it's a family business trust, one of the trustees needs to be an independent person as well. It may not be the family member. The executor can be the trustee as well. So it's not necessary to nominate anyone else. You can make your executor your trustee as well. The Percy, the ex-spouse husband, died without a will and no kids with a new spouse. The title deed still has the ex-spouse's name on it. I already explained to you what happens with regards to divorces. So if, like I explained, if the divorce settlement was not complied with yet, that should happen. If it is actually still in their names, I explained to you how the succession would work if there's no will. Then there is the question, then the last question I hand over to Ms. Hendricks because that is a legal aid question. Thank you.
So thank you. In terms of the administration of deceased estate, Legal Aid South Africa will be able to assist where there is a minor beneficiary involved. Where there's no minor beneficiary involved, we cannot assist. We normally have, and that is because in terms of the regulations to the Legal Aid South Africa Act, such matters are excluded from assistance. So what we normally do is we would normally refer clients to the Legal Practice Council so that they can hear whether in terms of the community service or pro bono, whether there are any conveyances that are willing to assist the family where they do not have any funds to do the conveyancing work pro bono. I just want to mention something on the transfer of the estate. Sometimes it's not the conveyancing part that is really the problem, but rather the outstanding liabilities on an immovable property. Remember, the conveyancer or Legal Aid South Africa will not be able to pay the outstanding liabilities, meaning the municipal accounts that have built up in terms of the house, the bond that is outstanding on the house. All those liabilities is something that must be paid from the estate. And if it cannot be paid from the estate, that is not something that the legal practitioner in terms of the conveyancing will be able to do. The conveyancer will only be able to assist with the actual transfer legal work that needs to be done. But as mentioned, we normally refer people to the Legal Practice Council to look at whether there is a conveyancer that will be able to assist pro bono with that. But unfortunately, Legal Aid South Africa will not be able to assist where there's no minor children. Where there are minor children, we will be able to assist with the estate. Thank you.
Thank you. I invite any other panelist that would want to make a contribution to do so now.
Thanks, Ms. Daniels. It's just to go off of the back of what Ms. Venter had said about the question asked by Percy about the ex-spouse who died without a will, and there's an issue about the current surviving spouse and them being married in community of property. So I think this question involves sort of two distinct areas. First, there's a divorce which needs to comply with the Divorce Act. And if it's a customary marriage, then dissolution in terms of the RCMA. And it also involves the assets which would have formed part of that divorce decree, which was an order of court. Also, what's implicated is that there would have been, for that first marriage, there would have been a matrimonial property system, as there would have been a matrimonial property system applicable for the subsequent marriage. So I think it's a difficult question because it implicates all of those. And if that first marriage was in a community of property, and that was an asset that was co-owned, so was part of the joint estate, then the deceased would have owned 50% of that asset. And how that is dealt with would be in terms of the decree of divorce. But if they bring that asset into the second marriage, that then is in the second marriage, which is also in community of property, that would be owned also in terms of that regime. Yeah, so Percy, I see, yeah, you also asked, you alluded to that question earlier, and how that asset devolves will be informed by their will or interstate succession and the marital regime. That's just what I had to add to that. Thank you.
Thanks for that. I just want to add to what Ms. Bertha has said. I want to try and answer the question in a very simple manner. The deceased, when he got dissolved from the marriage dissolved, the first marriage dissolved, he entered into the second marriage with half of the estate which does not belong to him. So it seems like both surviving spouses will have an entitlement to the total estate, with the first ex-spouse having to be entitled to the first half of the first marriage, and the deceased will carry over the remaining 50% of his estate into the second marriage. I hope that might provide some form of clarity. Thank you.
Thank you very much for that. We now move into the last 5 questions that we will be taking, whereafter we will close the Q&A session. So let's go to that. The first question is, we submitted a signed will and have been waiting from January 2023 until now. Still no response from Master's office. Why does it take so long and no one responds to emails? The second question is, if the value of the property in the estate exceeds 250,000, do you need to appoint an attorney? And what if there are no funds to pay an attorney? The next question. Hi there. I would like to find out if my deceased husband did a will without me included in the will, and we were married in community of property. My late husband left the house, which was still owing bond, and I had to pay it off to my stepson. How does one contest this? Then there's another question. Was sent over past year and a half to quite a lot of different email addresses to get response from someone, as no one answers the telephone or emails. I think this is a follow-up to, because it's an anonymous attendee, there's no names. It just says the original will was handed in 2003 until now, haven't heard anything. Then Zukisa Ghana says, can Legal Aid South Africa contact on Ghana z@ksd.gov.za. And the last question that we will be entertaining is, which pro bono practitioners can we approach to assist with conveyancing matters, especially in Pretoria CBD? Thank you. I will now hand over to the panelists to answer the questions, and then we will be closing. Thank you very much.
Thank you, Ms. Daniels. The first question, Ms. Banda, I think, Brigetti, if the value of estate is over 250,000, do you need to appoint an attorney? The short answer to that is not necessarily. However, it's actually much more intricate than just answering you with a yes or a no. When the estate exceeds the value of 250,000 Rand, an executor needs to be appointed who will have to comply with certain requirements within the Act on the administration of the estate. So the executor is personally responsible for the correct administration of the estate, and there are even sections in the Act that says, should the executor make a wrong distribution, they can be ordered to pay in double from what they made a wrong distribution of into the estate. So it's not something that you should just say, I'm not appointing an attorney because I don't have money. In a will, anyone can be nominated by the testator to be the executor of the estate. That person must then determine whether he or she will be able or up to the task of administering this estate. If they are not, they can get the assistance of a qualified person who need not be an attorney. It can be a trust company or auditor, to assist them to do the estate and make sure that they do what is necessary. However, the payment of the fee of that agent is not regulated by the Act. It is something that is agreed upon between the appointed executor and the agent. If you are the spouse or the child or the parent of the deceased, you need not get a professional person to assist you. If you are nominated, if there's been no will and the family nominate you, you need not get an attorney. But again, I'm saying, remember that there is a legal duty on you to comply with the relevant prescripts of the Act. And if you are not going to be able to do that, then you get professional assistance. Exactly how you will do with, for instance, your tax filing. If you are not a tax specialist, you will not attempt to do it on your own. You would rather get someone to assist you. With regards to that there's no money, unfortunately, that is one of the things that, okay, if you are the executor yourself, you can do it free of charge. If you do get someone, that person will have to be paid. Or if it is a professional person that's nominated in the will, or that is nominated by the heirs, that person will charge. Administrative fees are paid first out of the estate. Those includes the advertising of the account and so forth. So they are paid first. Then after them, the creditors are paid, and only then the heirs will inherit. And in order to pay those fees, sometimes assets will have to be sold. So like I was saying, it's not an easy, straightforward answer to give you, but that is the answer. Okay, so the next question, anonymous, which said her husband made a will and excluded her from the will, but they were married in community of property. Okay, your husband could have only dealt with his half share of the estate because your half share is your half share. However, as Ms. Botha, I think is her surname. Yeah, Ms. Botha explained with regards to the marriages. First, all the debts need to be paid before the half share can be determined. So I'm not sure why the bond was obviously in both of your names, but I'm not sure why you had to pay it off to your stepson, unless he said the house must go to his stepson, but he could have only actually gave him half share of the house. But if you want to contest the will, you will have to apply to court to contest the will, and you have to prove what you are alleging. And just because it's an unfair will does not mean that you can contest the will. Okay, I think Ms. Botha can come in there, more detail. Okay, the various email addresses and the lodgement of the will and the master not responding. Okay, you say that the original will was handed in at the master's office. Now, I hope that it was not only the will, but it was actually all the required registration documents. What you can do is you can access the master's web portal. there is a link on our website, and then you type in the ID number of the deceased, and it will show to you whether the estate has been registered or not. Most probably the master sent out what we call a J84, where they request further requirements, but you might not have received it due to the postal services. However, if they did issue it, you might be able to see it on the portal. When you click on the estate, you will be able to see the documents that have been issued. You will also be able to see whether an appointment letter has been issued. If not, however, if you still struggle, you can go onto our website again and check the contact details for the specific master's office. And I would suggest that you then contact the head of the office directly, give all the details, and then find out what's going on with your estate. If you are not being assisted, you are welcome to then, on the same contact details, you will get the details of the office of the chief master, where you can then lodge or escalate your complaint. Thank you, Ms. Daniels. That's all from me.
Thank you, Ms. Venter. Is there any other panelists that would want to add to the answers? Okay, it appears that there is no further answers. Can I just... Oh, Ms. Botha, thank you. Welcome.
Thanks, Ms. Daniels. Just to add to what Ms. Venter has answered to the anonymous attendee about the inclusion in the will, being married in community of property, and the late husband who left the house, which was still owning a bond, and had to pay it off to her stepson. In terms of the matrimonial property regime in which you were married, which was in community of property, because there was a joint estate, all the assets and liabilities form part of that joint estate. And it means that you are both jointly liable for the liability, one of which was the bond. But the executor, when winding up that joint estate, would have been required to pay off all the liabilities. And after paying off all the liabilities, the estate could then be sort of divided into equal shares. So I'm not sure why you would have had to pay it off to your stepson. He would have, in any event, in terms of a will, been able to inherit the deceased's 50% share of that asset. Yeah. I think that's all for now. Thanks.
Thank you very much for that clarification. We now move to, there's one hand that has been raised by Sukisa Ghana. You can now come in and raise your question, and after this, we will then close off the webinar. So can I ask Sukisa Ghana to please raise the question? Thank you.
Thank you very much, ma'am. Am I audible?
Yes, you are, sir. You can proceed.
Yes, ma'am. No, ma'am. I think I had already asked the question, but I think after the response that we got around the administration of deceased estates and indigent households in municipalities, I think I probably would have a follow-up of just putting some context into this discussion to say, beyond the issue of child-headed or child-headed households or households where there is a minor, households that are indigent are defined as households that lack the basic necessities and therefore that cannot afford any legal fees by themselves, and hence they are declared indigent already by the municipalities. Now, what normally becomes an issue is that we are then unable to process, in some instances, even their indigent applications, because the properties they are applying for, they are not in their names. And we can only deal with applicants who are applying for indigent status of their properties if the property is in their name. So at times this means that particular household will end up forfeiting the indigent household, and therefore the municipality ends up having to enforce credit control and debt collection on that household, despite the fact that it is actually indigent itself. So I think it is something that probably we may have to plead with Legal Aid South Africa and the department to consider going forward on how these households are really assisted so that they are able to benefit from this, particularly in light of what the president has recently said, where they have stepped out the funding for indigent households to about 77 billion, but some of them are still going to be left outside if they are not part of the register. So I thought it's not really a question, it's just a comment. Hence I had said the lady from Legal Aid South Africa, if they could contact us even outside of the webinar itself. Thank you very much.
Thank you, Zukisa Ghana. Your comment is noted, and I'm sure that the panelists have taken note of what you have raised, which is also a very important issue that relates to most of the South Africans. So with that being the last question, I will now close the webinar with a few comments. I'm sure that the presentations given today has highlighted the importance of having a will, as well as the administration of your estate and how it is done, the processes is done within the Master's Office. What you should therefore consider is when you are executing your will and doing your estate planning, you must take into account as well your marriage regime, which plays, as Ms. Botha has indicated, a very important role with regards to the administration of estates. So I hope that you have found the discussion fruitful and that we were able to address your questions. A special thanks to all the panelists for availing themselves and preparing presentations and sharing their knowledge with all of us to better equip us. Also, big thank you for everybody, for the audience that have participated by taking the time to listen to the webinar, as well as posing questions to us. I trust that we now know, have a better understanding of what it means with the administration, relating to the administration of estates, the importance of having a will, and special thanks goes to the officials that worked in the background to make sure that we were able to have this webinar and for it to take place. I now close the webinar and thank you all for your participation. Thank you.